Thanks everyone for coming and in person and watching online, if anyone's watching online. It's obviously a great opportunity to connect, share some insights and ideas. I suppose the presentation's primarily focused on appearing for parties of sufficient interest rather than appearing for a family or in the assisting team. Happy to take any questions on other issues or perspectives at the end on issues not covered. I'm sure a lot of you have a lot of experience appearing or instructing in the Coronial jurisdiction. Others may be new to it. Those of us who are litigators often come in at whatever level and feel that we don't have the same sense of control as we do in adversarial civil matters, where there's more of a template, a pleading or more rigour around the rules of evidence and around procedure. The immediate difference is no pleading, so often in the lead up to the inquest or during the inquest, it's quite a movable feast, quite dynamic. The statement of issues is always subject to change. It may be circulated in draft and have input from the parties. Usually that's just a bit of tinkering around expression. There may be some important points there. Phrases such as the standard of care often come out if there's a bit of objection around that, rather than anything really substantial. Ultimately, it's the coroner's call, and it can be difficult to sort of influence the scope of the inquest. And often there's this sort of circular process where whatever the case theory is, which might change, is based on, it sort of flows from the statement of issues, but that's based on expert evidence. And I'll talk about that a bit later. So there may be a focus or a particular direction because of the expert evidence, and that may well change, and there's often a really dynamic shift towards the inquest starting before there's been a real deep dive into some of the facts, because there's often sort of a cycle of supplementary statements coming in the last week or two. So sometimes, because this case theory is evolving just prior to and during the inquest, there can be a real inherent unfairness for the parties of sufficient interest that needs to be managed. So we'll give you some tips about how to manage those issues and step through some other more formal parts so that we're sort of pitched at all levels. On that point about the expert evidence influencing the direction, the relevant expert opinion may be missing, meaning that there may be one expert and then you might be thinking from the perspective of your client or whoever you represent that there's a crucial piece of expert evidence that's not in evidence yet. And we've been in court, Antonia and I, this week, where there's been one expert come in on a Friday, completely fresh, and prior to that, parties might be thinking we need one of those experts, and you might even get through the inquest and there may be a piece of the puzzle missing. There may be an adjournment, and the unfairness aspect is usually dealt with by giving a time to respond, and that may involve an adjournment or just having to really tool up and respond very quickly. I might talk in a bit more detail later about how you can try to influence the expert evidence if you can sort of get that to be refreshed. I don't really want to steal Antonia's thunder, but obviously coronial proceedings are primarily inquisitorial, but in reality they have adversarial and inquisitorial elements, and the coroner exercises judicial power in the proceedings that involve the administration of justice, and there's a case on that is up there. So I suppose what I'm thinking is that there's obviously this, it may be a bit esoteric or a matter of degree, but there is definitely a different vibe in inquest compared to adversarial proceedings, because the parties aren't driving it. It's driven according to a civil law model where the team assisting is driving the proceedings and they're calling the witnesses, so you don't call your own witnesses. So that's sort of how we hit on this metaphor for the uneasy feeling of lack of control. And I suppose it's an oxymoron, but the answer, I suppose, and I'll be interested in any input is probably yes, do you fight or swim with the current? Yes, you do both, really. I think that may be evident as we move through it. So there's probably judgment calls along the way about where to pick your battles, on which issues to really run and defend, and others where you might need to lead with your chin or accept some pain, and think about the downsides. And I'll talk later about reputational risk and the downsides of defending a position that probably won't be maintained. And that's a difficulty for a witness as an individual, or a witness who's an employee who's part of the reputation of the institution or organisation you might be appearing for. And then that leads into one of the best things you can do to defend either the interests of an individual or an organisation is preparing your witness as much as you can. There's sort of a grieving process, as in disciplinary proceedings, where probably at least one conference is a good idea, so that there can be some insight along the way. And optics become important in an inquest, as to a process where there's a tension between defending a position on behalf of your client and then a cooperation with the inquisitorial process. I might leave it there.
Sure.
And hand over to Antonia to talk through some of the formal parts of the jurisdiction.
Yes. Okay. So I'm going to start with some of the nuts and bolts and preliminary matters. So firstly, when an inquest is required to be held. So Section 27 of the Coroner's Act sets out the general circumstances in which an inquest is required to be held. And just going through that section. So an inquest is required to be held in the following circumstances: if it appears to the coroner concerned that the person died or might have died as a result of homicide, not including suicide; if the jurisdiction to hold the inquest arises under Section 23, which is concerned with deaths in custody and deaths in police operation; if it appears to the coroner concerned that it has not been sufficiently disclosed whether the person has died, or the person's identity and the date and place of the person's death have not been sufficiently disclosed; or if it appears to the coroner concerned that the manner and cause of the person's death have not been sufficiently disclosed. So for us in this room and online, it's usually that last circumstance where we come into play. So the word sufficiently must be given meaning. There will be cases where a coroner decides that the available information adequately discloses the general information about date, place, and manner and cause of death. And in those circumstances, the coroner may determine that it's appropriate to dispense with the inquest. Under Section 81 of the Coroner's Act, the coroner holding an inquest concerning the death or suspected death of a person must, at its conclusion or on its suspension, record in writing the coroner's findings, including in the case of an inquest that is being concluded, the manner and cause of the person's death. Determining the identity of the deceased, the date and place of the death, and the manner and cause of such a death has been described as the primary duty of the coroner. And there's a case for that, which is X and the Deputy State Coroner of New South Wales, 2001, New South Wales Supreme Court 46. However, another important purpose of an inquest is to enable the coroner to make recommendations. The power of the coroner to make recommendations is found in Section 82 of the Act. Recommendations are usually aimed at making improvements to public health and safety, and recommendations must be in relation to any matter connected with the death. Generally, recommendations are made in cases that involve systemic problems rather than one-off mishaps that result in a death. And therefore, if you're instructed to appear for a provider of a service, like a doctor or a hospital, you should give consideration well before the inquest to the types of recommendations that the coroner might be likely to entertain. If improvements in safety can or should be made, then it's likely to reflect well on your client at the inquest if it can be shown that those improvements have already been carried out. Consideration should also be given to contacting counsel assisting to obtain an idea of the type of recommendations that might be under consideration, so you and your client can consider them. So just on manner and cause of death, so that phrase is not defined in the Coroner's Act. Manner is defined in the Macquarie Online Dictionary as a way of doing, being done, mode of action. The same authority also defines cause as that which produces an effect. The effect under consideration is death, so the inquest must find, if possible, what has produced the death and how the death took place. So, for example, if one is inquiring into a death following a fall from a height, the cause of death would be the injury sustained in the fall. The manner of death would be how the fall came about. So, did the person jump, were they pushed, or did he fall accidentally? Hindsight bias is something I want to talk about. So, when drawing conclusions in relation to the issues to be determined at inquest, like manner and cause, the coroner must be mindful of the effect of hindsight bias and the need to understand the circumstances as they appeared at the relevant time to the people who were there. So hindsight bias is the tendency after the event to assume that events are more predictable or foreseeable than they really were. Hindsight, of course, is a very useful tool for learning lessons from an unfortunate event. However, it's not useful for understanding how the involved people comprehended the situation as it developed. In other words, there should be no hindsight bias or analysis with respect to the determination of manner and cause of death. However, hindsight analysis is common and of assistance with respect to the consideration of recommendations. I just have a little excerpt from the
recant.
No, sorry, that's next. So this is task of an inquest, which is not to apportion blame. So in an inquest, it's not a forum for determining civil liability, and this is State Coroner Derek Hand in the Thredbo landslide, where he's on said, the inquest plays an important function as a fact-finding exercise, essentially to investigate and answer the relatives' and public's need to know the cause of death, free from the constraints of inter-parties litigation. It does not apportion guilt, although not expressly prohibited by the Act, is not the function of the inquest to determine any question of civil, let alone criminal liability. So a coroner should not conclude that a person was negligent or has breached a legal duty of care in his or her findings, and although a coroner has no concern with future civil proceedings, interested parties may well be. In that regard, it's not improper for such interested persons to explore issues in examination of witnesses, provided that the questioning will assist the coroner to discharge his or her statutory functions. This is the relevant excerpt. So this is from the Chief Justice Law Reform Commission report in 1960 of the Coroner's Act. It states, insofar as the relevant facts and circumstances may also bear on civil liability, interested parties are prima facie entitled to be represented, and providing their questioning is confined to the matters relevant to the manner and cause of death, they can materially assist the coroner. But it is essential that the coroner confine himself to findings of fact and confines the parties interested to the facts relevant to the issues before them.
Sorry, 1960.
What else?
Himself. What's going on?
Yes,
Sorry.
yes. Okay, representation in coronial proceedings. So, section 57. Okay. The coroner in coronial proceedings may grant leave to any person who is, in the opinion of the coroner, has sufficient interest in the subject matter of the proceedings, to appear in person in the proceedings or to be represented by an Australian legal practitioner. Any person granted such leave may examine and cross-examine any witness on matters relevant to the proceedings. So, in addition to the relatives of the deceased, other persons having a sufficient interest to be granted to appear at an inquest may include any person or entity about whom the coroner may contemplate making comment in his or her findings. So authority for that is Annetson McCann, which is 1990 High Court, Australia 57. Any person against whom accusations of negligence, malpractice, dishonesty or any breach of any law may be made by another interested person are also within the class of persons who would be considered to have a sufficient interest to be granted leave to appear. Persons who have a substantial financial or other interest in the outcome of the inquest or inquiry, such as occupiers of premises, employers or even contractors, may also have a sufficient interest to be granted leave to appear. It should be kept in mind that person, for the purpose of section 57 of the Coroner's Act, includes a corporation, a body corporate, a body politic, as well as individuals. Okay. No, leave to appear. As there are no parties in an inquest, I apologise, I'm not great with the PowerPoint. Leave to appear. So, as there are no parties in the inquest, a person wishing to take part in the inquest must make an application for leave to appear. The application for leave to appear must be made before appearing. Procedurally, if a person wishes to seek leave to appear before the coroner, a letter should be written to the coroner's court or by first contacting counsel assisting or the instructing solicitor and advising the coroner of the intent. At the opening of the inquest or directions hearings, if there is one, the person or their legal representative should seek leave of the coroner to appear. Such leave is usually granted for the duration of the inquest. So the test under Section 57, which is not up there, of the Coroner's Act is whether the person has a sufficient interest in the subject matter of the particular inquest or inquiry. So it's necessary, therefore, for the coroner to consider applications of this nature by reference to the particular issues which might be determined by the coroner at the inquest or inquiry. The coroner, in consultation with counsel assisting, will identify before the inquest hearing the person or entities who appear to have sufficient interest in the subject matter of the proceedings. The main guiding principle is procedural fairness. It is possible that the inquest or participants in it will criticise a person or entity, or if it is possible that adverse findings might be made against them, then the coroner will usually direct that a sufficient interest letter be sent to that person or entity informing them of the inquest, pursuant to Section 54(1)(d) of the Coroner's Act. A sufficient interest letter informs the person or entity of the inquest and of their ability to make an application for leave to appear. Under Section 57(1) of the Coroner's Act, the sending of a sufficient interest letter to a person or entity does not mean, however, that the person or entity is obliged to make an application for leave to appear. As coroners are bound by procedural fairness, a sufficient interest letter might sometimes have been sent out of abundant caution. If you've been asked to provide advice on the question of whether to seek leave, making contact with counsel assisting will likely assist, as counsel assisting will be able to provide a better idea of the likely issues to be considered and whether your client's interests require active participation, no participation, or perhaps attending the inquest on a watching brief basis. There may be times when we're instructed to advise or assist witnesses who are not sufficient interested parties and are not entitled to representation. I think you have an example.
Yeah, a couple of things. I think I might have. I'll do it before I get. Before I forget, I've just got one thing in mind. I am going to talk about a couple of little things. Just tic tac. Good cop, bad cop. But one thing on the hindsight. Obviously, this might be an issue for counsel on their feet, or if you're working as a team, we'll talk about good ways to communicate. You might have a WhatsApp, or you might. I think it's good to brainstorm. With solicitors and counsel areas for cross-examination and issues that you want to probe or test, and those that may not benefit from that. One objection that I sometimes make successfully, or I may just be trying to get in the way of my opponent, is about a question that's posed and it's unclear about whether the question is putting a proposition that is prospective or with hindsight about facts at the time. And if the question is put with hindsight, then that can be a bit of a safe house if there is examination of issues that are going towards recommendations, and it may take pressure off the witness about what was happening at the time, and it can sometimes benefit your client. And also, if there's ambiguity, it may not read well in the transcript and it may not be received well. So sometimes it's good just to try to clarify what counsel assisting or one of the other legal teams is trying to get at in probing a witness about whether it is prospective and going to manner and cause, and therefore appropriateness of what was being done at the time that may have contributed to manner and cause, rather than the retrospective analysis that goes to recommendations. On the example, I also was just thinking about the situation where it may be so dynamic that I was in something last year where I was actually cross-examining a witness, and halfway through, the witness was, counsel assisting was concerned about the fact that the witness, who was a professional, a medical practitioner, had not been given a Section 57 letter and notice which allowed representation and access to the full brief of evidence. So we actually paused that witness's evidence, and then that witness came back another day with representation and access to the whole brief. So it can be that dynamic, but usually it's in the order that Antonia's been talking about. One example, which was quite frustrating for me, and actually someone in this room might have been involved, is appearing for more than one individual or professionals or doctors in death in custody, where to try to cut it short, there's a consideration of time required for brain surgery, and there's an MDT, a multidisciplinary team, that considers that issue, and you've got the seniority of the senior specialist and perhaps a less senior specialist, and then the junior person who's in training, who's a registrar. And the two more senior practitioners who were making the decisions seemed to be in the gun, and they were on notice and had sufficient interest letters and representation, and had provided statements, and then later had access to the full brief if needed. And the more junior practitioner who was not represented, so every time, what I would do is foreshadow at the start, I don't represent this person, Your Honour, but my instructing solicitor is supporting, the person, even though they're not a party of sufficient interest. The way it played out later on was that the two more senior practitioners came through unscathed, partly because they could back up what was done by reference to the MDT and other issues. But it didn't stop, despite me getting on my feet at times to point out the fact that this witness had not had notice and wasn't afforded the same procedural fairness as the others. In the findings, there was commentary which was, probably considered to be factual. There was a lost opportunity, there was something that wasn't done, which just seemed a bit unfair to me throughout. So it's just something to be aware of. It's not going to stop if you're appearing for an institution, perhaps where there's a different grade of representation or involvement, with notice for some witnesses and no notice for others. It doesn't stop things going in that way, and that's one of these uneasy senses of loss of control, that the inquest has its own energy, and sometimes you feel like you're along for the ride and it might not be a good one. I'll let you get back to your
Nuts and bolts.
Okay. If that's all right.
So back to the Act. So Section 58, Rules and Procedure for Evidence. So a coroner in coronial proceedings is not bound to observe the rules of evidence and evidence that are applicable to proceedings before the court of law. So the absence of rules of evidence and procedure is one of the hallmarks of the coronial jurisdiction, and I'm going to discuss a few aspects of the evidence in coronial inquests. So namely, evidentiary statements, legal professional privilege, and public interest immunity. Firstly, with provision of statements. So a police officer is assigned to be officer in charge, so the OIC, of the coronial investigation. Section 51 of the Coroner's Act empowers the coroner to give directions to the OIC for the purposes of the coronial investigation. So in practice, what usually happens is that the OIC is appointed at an early stage to conduct investigations. The OIC, usually in consultation with counsel assisting the coroner, will then try to obtain statements from all relevant witnesses and obtain all other material evidence for the purpose of compiling the brief of evidence for the inquest. It sometimes can occur that a witness will refuse to cooperate in providing a statement to the OIC. Sometimes also a witness will refuse to provide a statement to the OIC but indicate that a statement will be prepared by their own lawyer. But there's no power in the OIC or the coroner to compel a witness to provide a statement. However, it should be remembered that if an important witness refuses to provide a statement or supplies a statement that's not comprehensive, then it's far more likely that the witness will be placed on the witness list and be subpoenaed to give oral evidence at the inquest, and is likely to spend more time in the witness box. So clients who are reluctant to cooperate in providing a comprehensive statement should be advised of that risk. Legal professional privilege. Okay, so whether Section 58 of the Coroner's Act overrides legal professional privilege has never been formally decided. However, it has been held that legal professional privilege or client legal privilege in the Evidence Act is an important common law right or immunity that will not be taken to have been abolished by statutory provisions except by express language or clear and unmistakable implications. And the authority for that is Baker and Campbell, which is the High Court Matter 1983, CLR 52, so 153 CLR 52, and AWB Limited and Coal, which I'll talk about again. So in order for information to attract legal professional privilege, it must have been brought about or into existence for the dominant purpose of seeking legal advice or with reference to litigation, whether actual or contemplated. And I'm sure we've all heard of the High Court case of ESO. So communications passing between third parties, such as expert witnesses and lawyers or clients, will be protected only where they are made in contemplation of existing or anticipated litigation and for the purposes of use in litigation. So looking at the language of Section 58 of the Coroners Act, it would appear that it falls short of the express language that would be required for legal professional privilege to be abrogated. However, my personal view is that legal professional privilege does not attach to statements provided to the coroner for the purpose of coronial proceedings. And I say this because I previously prepared quite recently a motion on this very point. I was acting for the plaintiffs in a personal injury matter. In civil proceedings, a family member had died. There was coronial investigation into the deaths of the family members who had died. And as a result of that coronial investigation, statements were generated and provided to the police, the OIC. In the civil proceedings, a subpoena was issued to the police for access to those statements made in relation to the coronial proceedings. So the defendant in the civil proceedings claimed that those statements were subject to legal professional privilege. So the Evidence Act refers to two types of privilege. So there's advice privilege under Section 118 and litigation privilege under Section 119. So the statements in question were prepared by potential witnesses of fact, therefore they contain no advice. So the argument was that advice privilege doesn't apply. With respect to litigation privilege, in summary, the plaintiff contended that, firstly, proceedings before a coroner are not adversarial in nature, so they're inquisitorial and investigative. But secondly, there's no parties in an inquest, like there is in litigation. And Section 1119 specifically refers to a client objecting to adducing evidence that may disclose a confidential communication or document that was prepared or made for the dominant purpose of the client being provided with professional legal services relating to a proceedings in which the client is or may or might have been a party. So it's those two aspects, the adversarial nature and the fact that it requires a party, were the main submissions to why the legal professional privilege didn't attach to the statements. But further, the plaintiffs also relied upon it's a High Court matter of AWB and Coal, which concerned an unintentional disclosure of a document by solicitors for AWB to the Coal Royal Commission or the Oil for Food Inquiry, who then later claimed that the document was subject to legal professional privilege and had been prepared for the purposes of the inquiry. So the Commissioner in the Oil for Food Inquiry ruled that under the common law, no privilege could apply. That finding or ruling was challenged by the company but upheld in the federal court, where His Honour Justice Young said, paragraph 158 of that judgment, the reason why litigation privilege has been recognised as a substantive rule of law and a fundamental right is that it operates to secure a fair civil or criminal trial within our adversarial system of justice. The rationale for litigation privilege does not support its extension into a commission of inquiry. So the plaintiffs also contended that the statements should be accessed on public policy grounds. That is, that the administration of justice and investigative procedures provides that there should be unfettered access to all relevant information. And again, that's ESO. And that to characterise the purpose of the provision of factual information to a coroner in the form of statements as anything other than open disclosure and public investigation would be inconsistent with public policy. So in any event, after written submissions were filed and served, the coronial statements were handed over, so the point was never determined, which is a bit disappointing. So yes, now, public interest immunity. Okay. Public interest immunity refers to the rule that a court will not compel or permit disclosure of information which would be injurious to public interest. And there's the main authority for that, Sankey and Whitlam. The question that must be addressed by the court is whether the public interest in submitting the material outweighs the public interest in preserving confidentiality. So an objection may be made to the production of a document because it would be against public interest to disclose its contents, or because the document belongs to a class of documents which in the public interest ought not be produced, whether or not it would be harmful to disclose the contents of the particular document. Examples of documents which have been held to be subject to public interest immunity include cabinet minutes, material that would directly or indirectly disclose the identity of an informer to a government agency, material that would disclose confidential policing methodology, material to the disclosure of which may compromise a current police investigation, and documents whose disclosure would adversely affect national security, such as military documents. Like legal professional privilege, public interest immunity will not be abolished except by express statutory language, and the language of Section 58 of the Coroners Act probably falls short of the express language which would be required in this regard, and therefore public interest immunity still exists in the context of coronial inquiries. You're on self-incrimination.
I will, yeah, I am incriminating myself, but I think a couple of things that, again, little thought bubbles. I do have a war story. How are we going for time? Yeah, we won't probably crack on, but it just triggered a memory, not completely traumatic, but counsel assisting in the investigative team will try to obtain statements from all relevant witnesses. I was in a bushfire inquiry that ran just coming out of COVID for about 4 weeks, and after hearing expert evidence from an expert in Texas and an expert in UNSW about what caused the fire, some pretty intense evidence, and there was a task force that was set up to investigate the cause of the fire, and there was a class action that followed it, which finished up last year. But despite all of the resources, you cannot always turn over every stone or rock, and after 2 weeks of evidence, there was a RFS officer who had been watching online, because we were going to actually run it. Adam Castleton SC was counsel assisting. We were going to run it and go down the south coast, but because of COVID restrictions we couldn't, so everyone was on their laptops and it was all streamed. And after all the expert evidence fighting about tree 2, tree 4, and which pole was hit at which time that started the fire, an RFS officer went to the local police and said, I've got a photo of that on my phone. Oh, can we take a statement? Oh, it actually completely disproved one of the case theories about one of the trees and poles after 2 weeks of evidence, and the Texas expert was probably right, but it was a very expensive process, and you can't always in these processes speak to everyone, so expect the unexpected. On the other issue, the other thought bubble I had was around there's a whole other issue around admissibility of coronial evidence when you get to civil proceedings, if you've got concurrent proceedings. And in that bushfire class action, which I was in and I'd been in the inquiry, there was a fight all the way through, and some witnesses refused to give evidence, and there was a lot of argument all the way through about admissibility and a lot of objections about all sorts of aspects of different types of evidence. And I suppose a rule of thumb would be that if you've got factual evidence such as photos or video or other forensic stuff that's pretty basic, it's pretty objective, then you can probably bet that will get into evidence in concurrent or subsequent civil proceedings. Do not, whichever side you're on, don't expect or assume that statements that are provided for the purpose of a coronial investigation are just going to go straight into evidence in civil proceedings. There should be a lot of scrutiny of that, and that should not happen as a matter of course, but it's a whole other area. And also on the important area that Antonia's just been talking about, the public interest immunity, there is another whole area of NPOs that we're happy to take questions on, but it's something that we deal with in particularly deaths in custody in the custodial setting and other settings where there are a lot of security and other issues, and tension between countervailing interests that don't mean we just hand everything over, it's produced and then it goes into evidence. There's a number of ways to manage that with NPOs, redaction, and also notice about applications being made, but it's a whole other area. Just flag that. But on the section 61 aspect of privilege in respect of self-incrimination, there's a provision in section 58 that allows a witness to object to a question or providing a document on the basis that that might incriminate them or expose them to a civil penalty, and that's the trigger. That's going to be the trigger for your application if you get to that point. The certificate provision in section 61 is equivalent to section 128 of the Evidence Act. If the witness is compelled to give the evidence. So, do we have we've got that slide. I might not just step through it, but I've actually had a recent example where, and I think I do talk about later about the sequence of giving a statement. An individual or a factual witness may give a statement, usually without the benefit of the brief of evidence, depending on the timing, and then the brief of evidence will come in later, and there may be a supplementary statement. So I was appearing in that matter for a doctor. It was a death in custody in the custodial setting, but the doctor within that institution gave a statement based on the evidence available to him at that time, which was incomplete. So prepared a statement based on available records. Brief of evidence comes in, supplementary statement. Then in cross-examination, another party who was one of the other, there was a witness and their representatives who were appearing for, was a nurse who was involved, team approach to prescribing an assay medication, and there's an authorisation process. All of the documents about medication chart, the medication sheet and the authority were missing, and then they appeared and he was in the middle of his cross-examination. So that was an obvious situation where I got leave to conference with him on the Section 61 issue to give more defined advice about that process. It's not always a go-to. It's, again, the optics of the inquest. It's not always something where, even though witnesses might be under pressure, it's not as if you necessarily want to go straight there. It's a matter for instructions. So, there is a delicate balance between protecting the witness's interests and also drawing attention or unnecessary focus to the issue and perhaps giving it energy. I suppose if you're advising about that, bear in mind that Section 61 certificate protects the witness with regard to their own evidence only. It's not going to protect them with regard to evidence in source documents if there's something factual, objective. It's not going to protect with regard to criticism by experts. It's not going to protect them with regard to other witnesses verbaling them. So there may be limited utility, and you have to balance that. But some witnesses, when they're really under pressure, they're going to appreciate the security they might feel, and also if there's a risk of referral or serious adverse commentary, then probably everyone is going to feel a bit of comfort from having done everything that you can, even though it may be only a partial answer to that risk. So the application sort of goes like this. It's a bit of a conversation where there's an objection, and then the coroner will ask whoever's objecting, what is the basis of it, and then you step through the sections, and then the coroner will ask, what's the civil penalty, and if it is a health practitioner, then it's a fairly easy thing to say, well, there's a whole regime of disciplinary sanctions, and that's the civil penalty. And I'm usually pushing an open door when I'm making those applications, if you're in the right place to make that application. But it is a bit of a balancing act with most of these things. And then if the certificate is provided, the coroner will give a little ruling, and then usually the witness will give evidence with the protection of the certificate. Are you going to talk about
proper involvement of families?
Yep.
Okay.
Sure.
So it's just the last little bit that I wanted to talk about, and it's important. It's just the key authority on the proper involvement or the limits of family involvement in coronial proceedings. So the authority that I'm going to take everyone to is the Commissioner of Police and Attorney General for New South Wales, 2002, New South Wales Supreme Court. It's a judgment of Justice Wright, who referred to and summarised several authorities which have provided guidance as to the proper conduct of coronial proceedings, but with respect to the limit around the involvement of relatives of the deceased. So in that judgment, Justice Wright referred to the High Court's comments in Annex and McCann, and stated that it can be noted that neither Section 57 nor any other section of the Coroner's Act expressly entitles any interested party granted leave under Section 57 to make submissions. In Annex and McCann, the High Court considered the nature and extent of the rights of family members of the deceased who were given leave by a coroner under a provision similar to Section 57 to make submissions. So the majority held that the provision in that case did not exclude the rules of natural justice, and as a result, the coroner could not lawfully make any findings adverse to their interests without first giving them an opportunity to make submission against the making of such findings. It was, however, said that the requirement to afford procedural fairness in this way to the relatives did not extend to allowing them to make submissions on all issues in coronial proceedings. So the majority went on to say, it needs to be stressed that although the appellants, so the family members of the deceased, are entitled to make submissions concerning matters which are identified as possible sources of adverse findings concerning their interests, they have no right to make submissions on the general subject matter of the inquest. Their legal entitlement is confined to making submissions in respect of matters which they may be subject of adverse findings against them, personally or limited to assertions or denials. In opposing the making of any adverse finding, the appellants are entitled to put every rational argument open on the evidence, and when necessary to refer to and analyse the evidence to support that argument. In addition, the majority said that the contention that the grant of the right to appear gave relatives a general right to be heard on the subject matter of the inquiry should not be accepted. Justice Wright went on to say at 102, to summarise some of the main principles which apply to the proper conduct of coronial proceedings in light of the authorities and when the Coroner's Act is considered as a whole. In particular, Justice Wright stated that with the participation of interested parties who were given leave to appear and be represented, including save in exceptional circumstances, relatives of the deceased, but the participation by the relatives does not include the right to make submissions on the general subject matter of the inquest, because their legal entitlement is confined to making submissions in respect of matters which may be the subject of adverse findings against them, personally or against the deceased. And on the basis that the ability under Section 82 of the Coroner's Act to make recommendations is secondary to the primary duty to determine the manner and cause of death, and the ability to make recommendations does not provide a justification for a discursive inquiry into any possible causal connection, no matter how tenuous, between an act or omission or circumstance and the death of the deceased. So I thought that was a nice summary.
Mm-hmm. Very good. I think I've got a slide.
You do?
So we've talked about limits on cross-examination for and the family limits on the family's involvement. A textbook thing. I suppose I did have a note, personal note, to have a little ad for go-to guides. It's a bit of a Bible, the Wallers. There's a couple of other things. There's another Coronial manual. This is quite old. The 4th edition's. It's at least a decade old. The other things to be aware of are on the Coroner's Court website are the practice notes, and there's a general practice note, and there's a practice note about mandatory inquests, so deaths in custody and those sorts of inquests, and then there's also a First Nations protocol. Otherwise, any really difficult questions, or you just want to learn a bit or get a bit of advice about something other than speaking to counsel, if that's a go-to, Wallace is usually going to answer most of your questions if you've got a hard question. One aspect of procedural fairness, which is the touchstone here, obviously, Antonia's spoken you through the no rules of evidence and so on, and the stark difference between the rigour, perhaps, of the coronial jurisdiction and civil proceedings. is in cross-examination and propositions being put in expert evidence, the main go-to that you're going to have is around procedural fairness. It's not grounded in the rule in Brown and Dunn, which doesn't strictly apply. Is that my little?
Yeah, that's you.
I've got a little slide there. I won't read it to you, but even though the rule in Brown and Dunn doesn't apply, procedural fairness considerations mean that the substance of the allegations need to be put. If a party intends to make submissions in relation to that proposition about adverse findings that should be made against the witness, be it adverse commentary or particularly if they're going to seek a referral or something like that, and it may be that there's a few grades that I'll talk about of risk as far as adverse outcomes. So one of the main touchstones or reasons, I suppose, for that procedural fairness rule to apply is that it affects the party of sufficient interest's reputation, and there may be other sanctions, even their employment or other disciplinary proceedings. So what does that mean? I mean, broadly, procedural fairness is the right of the party to be heard and also having access to a fair decision maker. So the coroner's role in that is really to be fair to the witness. It's an expression that I use in most of my objections, is in fairness to the witness. It's a good mindset to get into, but you can sort of dress other things up that you do in adversarial proceedings as fairness issues. That's really where your mind should be at as far as approach. So yeah, I mean, the overarching rule, we might have said a little bit about this, but the coroner's task is to administer substantial justice, so that's why this is relevant and applies. The coroner's got some latitude to sort of inform themselves about what they consider is appropriate. In the ACT bushfires, there was a case that was an appeal in relation to the procedure in the ACT bushfires, and the commentary there was that relevance and reliability of evidence is important, but there is a liberal approach. There's some latitude for the coroner. The role of counsel assisting is to adduce the evidence objectively and in a full and fair manner. So that means that they should put both beneficial and adverse propositions to a witness and give them an opportunity to respond. And they should be seeking to establish the facts concerning a particular matter and eliciting the evidence that supports or contradicts a significant issue from which factual findings might be made. So definitely there is a fairness issue about putting adverse propositions and allowing the witness to respond and give evidence. And sometimes it might be, if there's something by surprise, that there's an adjournment required, or if there's something that comes up before the witness is in the box, then you might go into a supplementary statement to deal with something like that if it's last minute. Yes, and one of the submissions you could make is that there needs to be some rigour around that. It's not just a completely slapdash sort of approach. Expert evidence, I might move on to that. And I talked earlier on about the circular sort of reasoning about chicken and egg of what defines the scope of the inquest and the direction. And I think Antonia's talked about manner and cause being really the task of the coroner and not standards of care, but you'll find that there'll be a grey area where in evidence being adduced about what's contributed to the manner and cause of death, that appropriateness or gaps in management and care, or whether it's a healthcare setting or whatever setting it is, will start sounding like a standard of care, and it may be pushed in a policy direction, and the coroner, might be, and the counsel assisting might be speaking in those terms, particularly in counsel assisting's opening and when the coroner's addressing witnesses, but then the tone might shift to be quite an individual matter when there are factual matters and there are obvious gaps. So it can sort of shift into more of a blame game, even though it's not stated to be that way, and that's certainly the intention at the start. It does sometimes shift in that direction. One thing that I sort of find frustrating, and we're probably dealing with it in some ways this week, but I'm not going to talk about this week because my opponent's sitting next to me. But recommendations, if you're appearing for an institution or organisation, you can object, and you can try to influence evidence towards being not just relevance isn't necessarily the touchstone, but certainly what's going to assist the coroner in relation to manner and cause, and also you want to get on board with consideration of recommendations that are going to make a difference, that are going to avoid this sort of outcome, this sort of death in the future. But the language in Section 82 is any matter connected with the death. So the way that it sort of runs is the coroner's there, and this is the cause of death. We think it might be that it's a number of potential causes of death, but even if it's one cause of death, and these are the policies that apply, or the protocols or the practices that apply to that manner and cause of death, while they're there, if there's something that's reasonably proximate to that, that's not too remote, then the coroner will go there because they have the latitude in Section 82. So that can be quite frustrating. You're not just defending what seems to be the real issue, you're defending a multitude, or at least more than one issue. Objections, you can think about objections to evidence before the inquest starts. If the expert opinion is not of a peer of the party of sufficient interest, if it's lay opinion, that's objectionable. If family members who are just giving a lay opinion, or they might be a nurse, or they might have expressed opinions that you might find scattered through the brief of evidence that aren't from the experts, then that may be able to be objected to. You'll be in a greyer territory if you've got professionals who are not the experts in the inquest, but then once they're in the witness box, the coroner actually finds out that they've got this great expertise and wants to hear from them, and they sort of become qualified on the run in the witness box as experts, or just experienced people in whatever the industry is. But you can think about some objections, and it may be if you don't have expertise that is a peer of whoever you're appearing for, or a witness within your organisation, then I have on occasion successfully objected to evidence from another specialty or expertise that's not a peer of the person and the witness that's being scrutinised. So those things are worth thinking about. As far as whether or not you should obtain your own expert, in response to either expert evidence from the team assisting or another issue, there's a real judgment call in there, and there'll be a consideration, I think, of strategically, do you want to draw attention to the issue? Do you want to risk an own goal where, it may be an own goal where there's one expert that's a bit equivocal on an issue, there's some risk for your client, and if you bring another expert of the same specialty or expertise, they might get together. There might be some, evidence concurrently, and it may be that your expert agrees with the other expert. There's just some risk in introducing your own expert, and it may be that you could be better served, depending on the case. If you're thinking about filling a gap, there's no expert in this area, then there's got to be good reason, and that can be a really good course at times, and that's done in matters I'm involved in. And other times, if it's really pretty equivocal, you might be better off saying, well, there's no expert of this expertise, so there wouldn't be a finding made. You wouldn't safely find that this is the way it should be done in that industry or with that profession. So there's a lot of judgment calls in that, but there are times when you need to go there, and it may be that also you can have a dirty expert or shadow, and that may be of assistance in cross-examination as well. Practical tips, I suppose, that, again, with that frustration or lack of control of not having a rigorous procedure and, you know, a statement of claim and a defence or whatever you're used to in adversarial proceedings, one thing that can be somewhat powerful or influence outcomes for your client beneficially can be if the expert stepping through the process, you know, there's initial brief of evidence and an expert's given an opinion either at the outset or just when the brief of evidence is put together and the brief of evidence is this big. By the time you get to the inquest, the brief of evidence is this big, and you might be thinking, gee, there's a real sensitivity for my client here, and the expert's given evidence on that suite of objective records, and there's all this other stuff. Don't feel there's nothing you can do, because you can go to the team assisting and you can either ask them squarely to put the evidence that's in the brief of evidence to the witness, or even introduce something else that's not in the brief of evidence and, you know, make a submission or go into writing to say, in our submission this is relevant, and we request that you put that to the expert. And sometimes a whole issue can fall away, and when it can be better to do that at times. It's a calculated risk, but it can be better to do that rather than trying to do it in the witness box where there's even, again, less control. I think I've talked about that. So I suppose reputational risk. As far as the grades, obviously the worst thing that can happen is a criminal referral of papers, and, you know, have been way back, I think, as a solicitor in an obstetric case. There was a really heavy-handed situation with police for wanting to refer a practitioner, and, you know, there's considerations of separate representation and conflicts of interest, and that's a very heavy-handed approach. I do have one little war story, and I'm trying to remember who I was working with, but appeared in a death in custody First Nations young fellow who died, and that it was really geared up. That I understand that someone in the family worked at the Aboriginal Legal Service, so they had a very senior Crown prosecutor, and our doctor came along, and I said, look, I really want you to get there the day before and just soak up the energy and see the scene, because this guy is going to rush you. He's going to push you in this direction and that direction, and, you know, and I think there was the evidence went on, and there was even 2 days of prep, and he's sitting there soaking it all up, and just because there was a lot of, you know, talk about referrals. It's the only situation where it's actually like he was drowning in the witness box. He was sort of putting his hand up and saying, Your Honour, can I speak to Tim? He was calling, there was like, seriously, like, help, I'm drowning. That's not the usual situation. That's quite unusual, but you really want to try to acclimatise your witnesses. You usually understand when you're in the sort of case where there's, you know, risk of criminal referrals. Much more likely you're going to be dealing with adverse criticism or potentially a disciplinary referral, and your response to that is going to be either as an advocate or through counsel that this has got to be really done on rigorous evidence. It's got to be tested both sides of, you know, as I was saying before, in fairness to the witness should be put, and there should really be some procedural fairness and to allow the witness to respond. You don't just refer people willy-nilly, and insight, which is so key in disciplinary proceedings, can often save a witness who's at risk if they, you know, if you're thinking with the disciplinary proceedings hat on, you know, risk-averse panel will be thinking, is this doctor safe? Is this practitioner safe? If they can demonstrate insight and learn from whatever's gone down, then they're going to mitigate that risk to quite an extent. But there are times, as I gave that earlier example, where there's a lack of control and someone else throws you under the bus, or the witness collapses, or the coroner takes a really tough view of something, and you might think, I really didn't have much notice of that, and it appears in the findings. So all you can do is set and train as much as you can in preparing your witness, and just try to ensure as much fairness in the process as you can. And that probably leads into the institutional side of things, where policies are being scrutinised. I don't know whether I've probably ripped through a little bit.
Institutions.
Pardon?
Or,
Yeah.
Yeah.
That'd be good. So depending, I mean, obviously in bushfires there was a energy regulator called IPART, and the case I gave an example of earlier was all about hazard trees. And the thing that you do in a perfect world to stop hazard trees falling and starting fires is you train the scopers, because the scopers have done a Cert 4 or whatever, and we can't have arborists. So that resonates in other professions. If you had this sort of a specialist in a healthcare situation, or you had that sort of a professional in another situation, or you had certain training, then risks would be coming down towards zero. We don't have a zero risk community, and we can't afford it. So in those matters, IPART actually received a submission about training of these scopers, sort of not a whole way towards becoming an arborist, because we don't have enough arborists to go around. But if you train the scopers, then maybe we'll find more hazard trees and stop fires. And IPART in that case said, no, it's too expensive because all of our energy bills are going to go up, so please don't do that. Unfortunately, then we have fires that take out communities. So there can be regulation in a number of industries, legislative frameworks, and requirements of, I think I've jumped down to contractual obligations, which can be about confidentiality and so on. And there's all sorts of issues like funding and resourcing, and liability in other jurisdictions that will be in the backdrop to what you're thinking, and you might have to paint that context back in through your institutional witness. And I think, as Antonia said at the outset, one of the best things that you can do to sort of hide off that, when you've got all this noise around managing staff, traumatised staff, media, and all these other issues, one of the best things you can do, apart from preparing your witnesses so that they're in the best place when they get into evidence, and they're not defending issues that they're not going to ultimately be able to defend as individuals, which obviously that plays into the institution and the optics around that. But as far as the institution itself, if you can demonstrate that lessons have been learned and that improvements in policy and practice are in train, then you're going to head off a lot of that risk. And again, you're doing as much as you can to put your client in the best position and reduce all those risks. I might leave it there. Hopefully you found what we've had to say helpful and insightful. Any questions from anyone? Sean wants to ask something that I won't be able to answer.
I have one question. It's just around the notion of your view on unsolicited witness statements, perhaps being offered between the city council. Is that something that sometimes is worthwhile doing?
Meaning someone who has an interest as an organisation,
Yes.
sort of volunteering.
Yeah, because quite often you're requested to address particular questions in witness statements. Just from a point of view on,
Well, I think, yeah.
if you have a view on issues and that there is something that might be being missed, or is it worthwhile seeking to elicit something additional?
I think it is in the right circumstances. It's obviously there's a tension between the individual's position and if they're being put at risk, and obviously you make those forensic calls all the time where you're thinking there's a witness who could give some evidence on this, and perhaps a witness is being asked about issues that are above their pay grade and out of scope, and then you're thinking, well, someone else could give evidence about this, but then you'd be exposing them to the scrutiny, and is that going to go well or not so well? But there are cases where I think it is beneficial, certainly if the witness is not individually at significant risk, and there is an overall strategic benefit to your organisation, and they're the right person to give the evidence, then I think it is worthwhile, particularly if there's an important gap. But it's obviously a balancing and very strategic. And then we have, I suppose, the other thing is, in our experience, where there's that tension of sometimes you have a situation where it might be convenient that whoever's giving the institutional statement and is the senior management person in that leadership role is the current person and is not able to speak to the events, and that can be hived off quite well, and other times it doesn't go so well, and then speaking to that gap where the allegations are going against the person who's no longer in the role, is unavailable, that's something that we've encountered that's problematic as well. So it is that balancing. You don't always get to pick and choose who your institutional witness is or who they go to, and you can pivot and say, well, team assisting, actually, this is the better person, and usually you're pushing an open door in that if you're able to. And also there's that dynamic where there's all this work that's come to the team assisting, and obviously these days it's less likely to be the police. I've had historically as a junior, solicitor or whatever, it was much more the police at times, and then you'd have this sort of fight of, we'll provide the statement, rather than you still have those matters where the police say, we're doing all of this, and that's what happened in our bushfire matter. We're taking the CEO's statement next week. You can come if you want. As opposed to having a bit of latitude with the team assisting, Crown or DCJ are doing this, and then the request comes, and then you can provide the statement, and I suppose then you get into that issue of, do you lawyer it up, and because you have it a cross-examination now, how did you prepare your statement? Were you given a draft with a bundle, or did you? And that, I think you may have that practice of asking the witness to do the first draft, and then going from there, building from there. But sometimes you do have the comfort of being able to propose who gives that statement, and then there might be some sub-issues around middle management or another level that addresses the issue, and you might want to plug a gap. I think there's nothing wrong with that. It's just it's a risk assessment of which way,
Done.
I'm done.
All right.
All right.
Thank
Thank
you.
you.